All right. Good afternoon, everyone, and welcome. For those of you who don't know me, my name is Marissa Bluestein. I'm an assistant director at the Quattrone Center at Penn Carey Law School in Philadelphia. We host these meetings every month for folks who are engaged in wrongful conviction work, presenting trainings and discussions about issues that pertain to wrongful conviction litigations and investigations. This is funded through a cooperative agreement with the Bureau of Justice Assistance and the Office of Justice Policy, where the Quattrone Center is a TTA provider for the upholding the rule of law and preventing wrongful convictions grant. So today we are very, very pleased to have both Carl Schwartz and Katie Ernst with us. They worked together collaboratively on a case that you may have heard about in the news fairly recently, where a gentleman named C.J. Rice was exonerated after having served over 20 years in prison for a shooting that he did not commit. What is unique about this case, or what is important about this case that I've asked Katie and Carl to talk about, is the fact that it's centered in around ineffective assistance of counsel from the trial, and the fact that he had gone so long without being able to address those issues and through normal post-conviction processes. But this was on a subsequent or successor petition, habeas petition, where Mr. Rice was able to get relief. It's important to note that the District Attorney's Office is represented by Katie Ernst, who is not in the CIU, but rather she's in the Federal Litigation Unit. And Katie, correct me if I got that title wrong. But it reflects, I think, from the District Attorney of Philadelphia's perspective, their desire to really address these errors when they occur, as opposed to kind of waiting for them to go through a CIU process. And I think it's important to kind of keep in mind that this is not a typical CIU case, but it is something that is addressed through the way the Philadelphia District Attorney's Office has set up their appellate reviews. I'm going to let Carl and Katie correct anything I just said wrong first.
You're not wrong, but I'm the supervisor of the Federal Litigation Unit.
Even better. So I don't mean to downplay that at all, so thank you for correcting that, Katie. So we thought we'd start off just with a quick
Marissa, one other thing.
Carl,
this
please.
is not a successor pleading. I mean, it was successive in the sense that it was post-state habeas,
right.
But it was an initial habeas, and frankly, because it was so focused on IAC, had it been a successor, I think Mr. Rice would still be sitting in prison because the hurdles are pretty tough when we're talking about successors.
And thank you for correcting that. I appreciate that. And we'll be able to explain the process in Philadelphia, or Pennsylvania rather, and where it kind of lies in that. But thank you, Carl, for getting that. So I want to start with just a quick, about a 5-minute brief video that Jake Tapper, who's a correspondent with, I don't know, CNN, something like that, that he did. His father actually had been involved in the case at the trial level. He had been a pediatrician who had seen C.J. Rice in the days before the shooting happened, and would have fully testified had he been allowed at trial that it would have been physically impossible for C.J. to have committed the shooting because he could not walk or run the way that the shooter was described as doing. So the fact that his father was involved got Mr. Tapper interested in the case. He's written about it extensively and has called attention to it. And as I said, it has resolved on the issues of ineffectiveness of counsel. So let me kind of figure out where my share screen is and be able to get that over for you. Oops. Sorry, just 1 minute. Oh. No. I apologize. I think I forgot to share with sound on, so let me redo that for you. There it is. Okay.
Or granted the motion offered by the District Attorney Larry Krasner to drop all charges against C.J. Rice. C.J. Rice is now a free man. C.J. Rice has been completely exonerated. People watching might recall we've been covering this story for several years. C.J. Rice was the patient of my pediatrician father, and my dad testified that in 2011, there's no way C.J. could have committed the crime, this shooting. 3 or 4 people were wounded, nobody seriously. But CJ in 2013 was sentenced to 30 to 60 years in prison, as you noted, largely because he had a completely incompetent attorney. That was the cover story. I wrote a cover story for the Atlantic magazine in 2022 called "This Is Not Justice," a Philadelphia teenager and the empty promise of the Sixth Amendment, which guarantees people a right to fair, adequate counsel. And an attorney, Carl Schwartz, working with a number of other attorneys, filed a habeas petition not long after that. And the district attorney has now granted that habeas petition. And the court has said C.J. Rice did not get a fair trial, did not have adequate representation. The district attorney has concluded that the case was weak to begin with. The only reason he went to prison was because he had a bad attorney. And for the first time in the whole sorry history of this case, of the Commonwealth of Pennsylvania versus C.J. Rice, finally, justice has been served. Jim?
And Jake, what led the district attorney to this decision?
Well, obviously, the efforts of the lawyers, CJ's lawyers, Amelia Maxfield with the Innocence Project and now the Exoneration Project, Carl Schwartz. There were others that helped. Don Verrilli, the former Obama Solicitor General, people got involved. But what happened is the district attorney investigated the case for themselves and found that a lot of, first of all, that he had inadequate counsel, and that Sanjay Weaver, his attorney, who has since passed away, should never have granted any number of things that she did in court. For example, a theory of the case that this was a retaliation. There was no evidence that this was retaliation, but she granted that. But they also did their own investigation. They listened to jailhouse recordings of conversations CJ had with his mom, in which he was pleading to have his mom ask his attorney, Sanjay Weaver, to please get the phone records, because the cell phone records would prove that he was in West Philadelphia at the time of the shooting, not in South Philadelphia, something that Sanjay Weaver never did, something that the Philadelphia police apparently never did when they were investigating this case. So that was a big part of it. They also looked into other things that were very suspicious about the only person who said that CJ did this is one eyewitness who knew him, didn't identify him the night of the shooting, didn't identify him to hospital personnel, but then after police said they got an anonymous tip that CJ did it, suddenly she identified him. They found her testimony not particularly reliable. So they did their own investigation, and they concluded that this needed to be done, that he needed to be exonerated.
And this goes to the issue of defendants not having effective representation?
It does. And in fact, I talked to CJ Rice for a documentary we're doing about this case. It's going to air on Sunday on the whole story with Anderson Cooper. And if we have time, I'd love to run just a little clip of that interview that I did with CJ Rice. It's good to see you.
Good to see you, Jake.
You spent almost 13 years in prison. How does it feel to be out?
It feels amazing.
You said the air tastes sweeter.
The air tastes sweeter. The sunshine different. It's a different warmth. To feel the sun as a free man, that's... Can't put it into words.
So these letters from my dad, did you look forward to getting them?
I did.
Yeah?
I did. Like a lot.
Really?
Yeah, because it's a constant. So you get used to constants in jail, but most of them are demeaning or not so personal. But a letter with ink on it from somebody on the other side of the wall, that's personal.
Yeah.
That makes you feel human. The care and concern that your father had for me was genuine.
My dad always says that we don't have a justice system, we have a legal system, but there's no justice necessarily.
I can attest to that. I can attest to that.
Yo, I was gonna say hi. How you doing? Hey.
So there's C.J. Rice, who's now 30 years old. He went into prison when he was 17 years old when he turned himself in. He's now 30. He is a free man. His second chapter of his life begins today. And this really happened because of C.J. Rice and because of my father, who never stopped advocating for him during these 12-plus years he was in prison. We're going to have a lot more about this on
This very big development, Jake.
Here we go. The category is the calendar, the Final Jeopardy.
All right. Don't think we need about the Final Jeopardy answer, but there we are. Again, for those of you just joining us, thank you for being with us. We encourage folks, because we are not doing PowerPoints today or our other kind of, this is a discussion with Katie and with Carl. We encourage you to go on camera if you're comfortable so that we can do that. Carl, I'm going to kind of just jump in with you, if you don't mind. And you corrected me before in terms of the procedural posture of the case. If you could explain a bit about what you meant by this was a first habeas versus another, what was different about this, why were you able to raise these claims 12 years after a conviction when, we pretty much everybody on this call knows that generally it has to be done in the first or second appeal. What was different about this? And I'm going to shut up and just let you talk.
Sure. Well, the reality of practice over the last 10 or 20 years is that a person in CJ's position who is at the federal habeas stage is severely limited, much more so than in the past, and certainly more so before the codification of the right to habeas, the AEDPA. And I wouldn't want to bury the lead. We were lucky in CJ's case that what I think that Katie and her office regarded as perhaps the most compelling claim, and I think we had a lot of compelling claims, was a record-based claim, so that it bypassed the Shin versus Ramirez concern, right? Which is that if you have evidence that you need to develop in federal court, the Supreme Court has said too bad. They gave it with one hand by saying, we recognize that state post-conviction lawyers can be horribly ineffective, and that because that's your first opportunity to assess your trial lawyer's performance, you should get at least a second opportunity to raise those issues in federal court. Actually, a first opportunity in federal court, but a second opportunity. But that right was severely limited when they curtailed the development of evidence where you as the petitioner or defendant failed to raise the claim previously. And I think probably most of the folks in this audience know what I'm talking about, so I'm probably breaking this down too much. But and because the lawyer's failure is attributed to the client, that's a terribly regressive. It was a terribly regressive ruling, and it really has curtailed habeas practice. That said, if you haven't raised these issues in your first habeas proceeding, you're in a tough spot, because the hurdles for a successor habeas petition are higher than, frankly, any that I've seen in state court for state habeas proceedings. And short of actual innocence and newly discovered evidence that you could not have found previously, you're kind of out of luck. But fortunately, anytime we get a case, and our firm does a lot of post-conviction work, anytime we get a case where the defendant or petitioner is still, quote unquote, in court, in other words, he still has a right to a habeas, we feel like we have a chance, right? And that was the case with CJ, that we had a chance. And in thinking about addressing this group, right, and I suspect that most of the folks in this audience are as experienced and as Katie and I are, and probably have done, not probably, certainly have done great work all over the country. What occurred to me is, in a lot of ways, this case was really a classic IAC case. That I don't want to say garden variety, but it was pretty classic. And we saw two, kind of major failings, right? The first is that, trial defense lawyers, accept as whole cloth the government's sort of paradigm of the case, theory of the case, and they spend their time trying to shoot holes in it, right? And don't have an appreciation that the government's paradigm is winnowed down from all of the available evidence that is out there. You know, they decide, the prosecutor, the detectives decide what to chase down, what not to chase down, certainly what to present. And, you know, so this idea of a scorched earth investigation is critical, and it's critical at trial, and it's and the last gasp is in state or federal habeas. I mean, here, you know, if you look past the paradigm that was presented, you had all kinds of evidence that raised serious questions about CJ's guilt. You had these failures to ID that jump out of the hospital records, okay? And, you know, we raised this claim alternatively as a due process claim, as a Brady violation, but it really, and we also raised it as an IAC claim, but it was really an IAC claim. I mean, you have the sole eyewitness telling doctors and nurses, you know, I don't know who did it. I heard a shot. That's all I heard. None of that was presented to the jury, right? And it was not presented to the jury because the trial lawyer didn't go out and get the hospital records, probably because they weren't part of the discovery packet. The world doesn't begin and end. And again, I feel like I'm saying things to lawyers who know this already, but it doesn't hurt to hear it again, right? The world
Always
doesn't
good.
begin and end with the discovery packet, right? And all the lawyer had to do was order the hospital records. All the lawyer had to do was listen to the radio tape. That was not part of the discovery package, and they would have heard a presumptively reliable civilian homeowner witness tell police that there was but one shooter, not two shooters, right? And that was a critical fact, you know, in the case. All the defense lawyer had to do was go out and do an investigation of the scene, which, you know, which would have disclosed that the single eyewitness was not 20 feet away from the shooter, but we know there was a shooter because there were fired cartridge casings, but at least 60 feet away. And contrary to her testimony, there were no street lights around the shooter. There were no street lights anywhere near the shooter. Contrary to her testimony, her view was not unobstructed, right? So this kind of, you know, going out and creating a counter narrative from evidence, right? And that may be more accurate, certainly more fulsome than the narrative that was presented at trial. So that was kind of one takeaway, and that all related in our discussions with Katie and Pete Andrews, that all related to the question of prejudice, right? Like, how critical was the error that they saw as consequential? And in the face of that kind of unexplored evidence, even though we raised those as IAC and Brady claims, those issues were important to the prosecutor, I think, and I don't mean to speak for Katie, because they related to the question of would this other error, which I'm about to talk about, would it have made a difference? The other error relates to a second thing that mediocre, I don't want to say mediocre lawyers, but lawyers who are operating in a mediocre fashion do, which is they assume that jurors are like attorneys, and jurors know that even though they're suggesting a motive in this case, that doesn't mean the defendant is guilty. That doesn't prove guilt beyond a reasonable doubt. Jurors understand that, you know, and I've had discussions with colleagues who I have a lot of respect for, who suggest to me that, you know, trying to prevent that sort of collateral evidence that dirties up a client to stay out of the record, that I'm trying to clean up my client too much. But there's a term, presumption of innocence, right? Which means we're presuming, and the jury is presuming, if they follow the instruction, that the person who's on trial is as culpable as a human being as they are, right? So how is it possible that you can be too careful about sanitizing a client? And in this case, I had the sense that the lawyer just decided, you know what, the government has contends that the defendant, Mr. Rice, was a person of interest in the shooting of one of the victims. In this case, we're just going to stipulate it rather than have to deal with an evidentiary presentation. The problem with that, though, is there was no evidence to present. When you look past the Commonwealth's or the government's representation as to motive, there was no evidence that that the victim in this case was a person of interest in the shooting of Mr. Rice, who had been shot weeks earlier. Overlooking that kind of evidence is deadly, right? It's, you know, I was watching MSNBC and they were talking about the Trump trial. And listen, I'm not a Trump supporter, but I'm thinking, you know, what defense attorney is going to sit there while there's evidence of him standing there in his boxer shorts in the hotel room, even though that's not the critical issue in the case? You know, that kind of evidence that dirties up your client, especially in a close case on prejudice, it can't be ignored, and it was in this case. And so that's kind of the second deadly sin that you see all the time when you do this kind of work. It's almost like the defense lawyer thinks that he or she is trying the case as a bench trial, you know, and that the jurors understand, like judges understand, that this won't get you to guilt, but they don't. So thankfully, that combination of a very thin case with genuine reasonable doubt, genuine question of innocence, coupled with this devastatingly prejudicial stipulation, convinced a district attorney's office with tremendous amount of integrity, and who are no pushovers, to do the right thing in this case. I'm done, Katie.
Oh, sorry, I think Marissa was speaking, but she's.
Oh.
I was trying to, but you know, we have to have at least one. You're muted during a call, so I took it. So Katie, you kind of chuckled when Carl said the office is no pushover. I think, you know, folks, at least outside of Philadelphia, have this sense of the Krasner administration is kind of rolling over on a lot of exonerations. I can attest that that is not the case, that there's a thorough investigation and very thorough vetting of cases before any agreement is done. So if you could kind of maybe pick it up where Carl left off in terms of, you know, when this case comes to you in your office in the federal litigation unit, like, how did you approach this? Was this a different approach than other cases? You know, what was it about this, and how do you develop an ineffectiveness claim in particular when looking at something like this?
So because we're not a conviction integrity unit, we are the federal litigation unit. So we handle every single federal litigation case that comes before us. We don't agree to relief in the vast majority of cases because there aren't claims that would support relief. And so in those cases, we oppose relief. And Carl knows because we've opposed in many of his cases, and I'm sure he wishes we didn't have.
Are you doing it? Good. 2000.
So when this case came in, you might think that because this was a high profile case, we would have treated it differently. We really didn't. We treated it like we would any case. We thoroughly reviewed the pleadings and the record that we had for ourselves. And then we had a meeting with defense counsel, because if defense counsel wants to meet with us and, you know, present us with any additional information they may have, we're always willing to meet. So we met with Carl and his whole team, including people from the Pennsylvania Innocence Project, as well as Don Verrilli and people from his law firm. And at that meeting, we told them candidly the problems that we saw with a lot of their issues. Some of the claims that they raised, we didn't believe that there was prejudice from those claims. Some of the claims we thought had procedural barriers that would prevent relief. And actually about this claim that ultimately we did agree to relief on, I said in the meeting, the biggest problem that I see with this claim is that you're saying that what this attorney did was on a Friday, the judge basically indicated on the record, he told the parties that he didn't see how the Commonwealth could get this motive evidence in because they didn't have any evidence to support it. And said, unless the Commonwealth could bring evidence on Monday to support that motive, then he would preclude any reference to it. And then on Monday morning, she stipulates to it. I said, that is so obviously ineffective that it seems to me that there must have been something that happened between Friday and Monday. And Carl said something along the lines of, well, I can tell you I reviewed the whole file. I didn't find anything. And I said, well, Carl, I appreciate you and I trust you generally speaking, but it's a trust but verify situation. And of course, we're going to have to look extremely closely for ourselves to see if we can find anything in our file to suggest whether or not maybe there was some new information came up, and that would explain why she made this seemingly inexplicable stipulation. So we went through our file even more carefully and read every scrap of paper. Not only could not find any evidence to support the notion that something new had come up to support this, there was no evidence to support it. In fact, our gun violence task force, after relief was granted, did an even more thorough investigation to try to find new information and couldn't find any evidence to support it. But we actually found an email in the file from the prosecutors at the time that stated that they could not get this evidence in. They had no way of getting this evidence in. So at that point, we said, aha, I mean, this really must have been just an incredibly inexplicable and ineffective move. And that is what then motivated us to agree to relief.
And in that, so the investigation that you did, both within the file and external to that, kind of helped to bring that ineffectiveness to light. Is that what I'm hearing with that?
Right, because basically what I'm saying is that judge in the case on the Friday before the trial, which the trial began on a Monday, he said he was not going to permit this motive evidence to come in. That it was a suggestion that one of the victims of the shooting may have been the person who had shot C.J. Rice 3 weeks or some number of weeks before, of course, then giving Rice a massive motivation to shoot the victim in this case. And the judge said, you don't have any evidence to support that theory, so I'm not going to let you present that. And then on Friday, then on Monday morning of the trial, she stipulates to the fact that he was a person of interest in the shooting of the victim in this case. And so, once we could determine that there was no new evidence that came to light during that time frame that would have supported that stipulation, then clearly that action was ineffective.
So 2 questions that have been thrown at me. One is, why wasn't the ineffectiveness raised, and this is probably for Carl, raised in a state post-conviction? Why is this being raised for the first time in habeas?
I don't know.
It just wasn't done.
I don't know. I do know that state post-conviction counsel was a very stand-up guy and gave us a declaration that we filed of record that he had no reasonable basis not to raise it. Let me just say quickly that for those habeas wonks in the audience, I was of the opinion, and still am, that based on the Commonwealth's, we say Commonwealth, well, I guess most of you are from Pennsylvania, maybe not, we say Commonwealth in Pennsylvania, based on the Commonwealth's representations at the hearing on Friday, I felt that the record was pretty clear vis-a-vis Shin, that they had no evidence. Nevertheless, and I always thought this, that once they discovered the email, if that email was necessary to demonstrate that they had no evidence, I think you get outside of Shin there, because there's no failure to develop, right? I mean, that's hidden in their file. So I kind of felt that we were solid procedurally. We never came to that because, as I said, this is a decent office, and maybe this is a good time to. I know I'm talking a lot, but I want to make this.
You're here, Carl.
I want to make this point about their office, and Katie, I can't say enough about Katie, and there's a tradition there. Before Katie, there was a guy named Matt Stiegler, and he too occupied her role, and he too, was very courageous about doing the right thing. And I know there's a lot of feedback about what has happened to the advocacy process. I mean, where's the person advocating to retain the conviction? I am here to tell you that in a lot of these exonerations, the evidence in support of concession is so strong that a responsible prosecutor's office never would have brought the case in the first place. I think that's this case. And why do you need someone advocating a position of retaining a conviction in a scenario where a prosecutor's office with integrity never would have brought the case in the first place? This is not a situation where they're making credibility they're second guessing jurors' credibility determinations, or second guessing the degree to which the jurors dismissed evidence of that raised questions about guilt. I think in the vast majority of these cases, once they've completed their investigation, there really is no other side. And, there's something nefarious and ugly about creating a straw man, essentially, to argue that a person should remain in jail in a case that never should have been brought in the first place. So I think that that's a real red herring. And I believe in the advocacy system. We're not France. This is not an inquisitorial system. On the other hand, a case that is as foul as, say, this one, there is no other side. And, I leave it to the prosecutor to make that determination, and if the determination is not, to my liking, then I can resort to the court, and we do that, and we've prevailed in some cases.
I think that kind of raises the clarification in terms of that. Was there a hearing here in front of the federal court at all, or was this done on pleadings? And I guess I'll ask Katie to take that one.
Yeah, so it was done on the pleadings. So Carl had written a petition with 10 or so claims, and then we responded based on this one that we thought entitled Rice to Relief, and then the court granted relief based upon our response. And as Carl said, other than this email that we had found, that is what really cemented it in our mind that there was no strategic basis for the decision-making process. Everything was record-based, so there really was no reason for there to be a hearing.
I'm sorry, just that kind of leads to the other question that was thrown at me. So the lawyer, of course, was ceased by the time this comes to court. Was that ever an issue for the court that they couldn't ask her, whether she had strategic basis for making the decisions, or was it just clear enough on the pleadings that you provided that there could not be one?
Right. So if a lawyer is deceased, then the standard is whether there could ever be a reasonable basis for doing a particular action. And that's why we wanted to search for any piece of evidence we possibly could to determine whether there could have been some outside reason for why she did this. And we couldn't find any.
So you were kind of anticipating the court's questions before even doing the filings.
Correct. And so then that was part of our response to explain that, we've done this incredibly thorough review. Here's the facts of the case. Here are the weaknesses of the case to begin with. He had a co-defendant that was acquitted. And in fact, during the trial, it was proven that his co-defendant could not have done it because he was on video somewhere else. So the jury already didn't believe part of the Commonwealth's theory here. The jury deliberated for an extremely long time. We know this was a very close case. And so then that's why, given this, ineffective action taken by the defense attorney, and then also, as Carl said, while we may not have thought some of the other claims that he raised were winning claims for various procedural or other reasons, there were still concerning aspects that suggested that the attorney was just generally not prepared.
And there's just kind of a note in the chat from one of the folks from Florida, just saying that in her state, it's not likely that they would get such a concession from the district attorney's office or from the prosecutor's office, that other states wouldn't. And I don't know if this is a Carl question or a Katie question, but for folks in jurisdictions where either the prosecutors themselves on this call are having trouble getting their offices to agree to relief in particularly strong cases, or if they're dealing with an office that is maybe not as kind of open to concession as Philadelphia, what would you have to say to them, particularly on cases of IAC?
Well, I would just say that I mean, I obviously I can't say what you can do to make a prosecutor's office do something that they don't want to do, but as to ineffectiveness claims in general, it's nearly impossible for an ineffectiveness claim to lead to an exoneration, and an ineffectiveness claim by itself, because presumably there was sufficient evidence for conviction because the person was in fact convicted, and theoretically you haven't found anything particularly new. I mean, this isn't, Brady material, or every now and again, maybe there could be an ineffectiveness claim for not finding some other witness. But in a case like this, it really just comes down to the standard of a reasonable probability of a different outcome, which is not an insignificant standard, but it's not the highest standard that exists. And so at the end, we reinvestigated the case after relief was granted. Our gun violence task force did very extensively, hiring experts and consulting, doing much a great deal of additional investigation to see whether we wanted to re-prosecute CJ Rice. And ultimately, they determined that we do not have guilt beyond a reasonable doubt to where it would be appropriate for us to bring charges. But we have never said that our office has found that he is likely innocent, because we also could not find new evidence to conclusively establish his innocence either. And so I think that's why a lot of district attorneys' offices often are hesitant to agree to relief in ineffectiveness cases, because they're not cases where you can conclusively establish innocence.
And forget ineffectiveness cases, even due process cases. I do death work in Ohio, Arkansas, Delaware, Texas, and have never gotten any consideration along these lines. Never. Not for lack of trying. I mean, and I know there's at least one lawyer in this group that I'm sure her experience is similar to mine. You keep trying, but it's, there's this passion to hold on to convictions and to try to get guys executed. And I've never had any success in that regard, without having to go to court and trying to win in the courtroom.
Well, I just want to add to that too. So Jake Tapper, of course, reported on this case extensively after the fact. And there was an article where he gave an interview with the Philadelphia Inquirer, and he said that Don Varelli, who is the former Solicitor General of the United States that helped Carl out with this case, that he said that he had never had an encounter with prosecutors who are more committed to the sense of justice, as opposed to just keeping people locked up, whether they're guilty or innocent, than the situation he had when he met the attorneys who worked for Krasner. And honestly, I find that very sad, because as I said, what we did in this case is what we do with every case. We had a meeting with them. I told them that I thought there were lots of problems with their claims. We pushed back quite a bit in this meeting. And then we just did a full investigation to see where the facts would lead. And ultimately, we determined that the facts and the law compelled relief in this case. And I wish that were a more common thing.
Marissa, and I agree. Marissa, somebody raised a question that I was expecting about Dr. Tapper's testimony.
Right.
Let me say this. I thought that it was presented, rather ineffectually, his testimony, rather ineffectually at trial. And I, in good faith, believe that there was a habeas claim, an IAC claim that warranted relief. But Katie's office had a different take on it. And I interviewed a couple of experts who also who weren't affiliated with the case initially, who also had a different, in any event, they had a different take on it. And at the end of the day, while I thought that was a viable claim, that is not the claim that got CJ relief. And there are a number of medical experts, I think, who would have come in and said a person who was drugged up, and riled up, and adrenaline was flowing, after a couple of weeks, would have been able to do, and had been injured in the way CJ was injured, would have been able to do what the actor did in that case. So you're right, and isn't that often the case, right? That when a case gets national news and people get worked up about one particular issue, that isn't always the issue that that got the defendant relief. And that was not the issue in this case. His impaired condition was not the issue that got CJ relief, and I don't think it would have, based on my discussions with Katie and her associates. I'm right about that, Katie, right?
No,
I'm not right?
no. I mean, we were not particularly compelled by the claim.
Right. So Katie, there's a question in the chat for you about whether you interviewed the trial prosecutors, and if so, what they thought of the IAC claim. If you didn't, and if you are free to talk about it, why not?
So I've been talking about this, and only just because of, I've been talking about this as if I handled the case, but as Carl mentioned, it was actually Peter Andrews, who was in my unit at the time. He's now with the with the DOJ. And so he's the one that looked through all these documents, found that email, contacted every person he could contact. And I'm racking my brain, and we generally do contact every witness, but I don't have a particular recollection as to what the trial prosecutor had to say.
And then Carl, another question came in for you. And so if you knew that the kind of medical testimony was not going to be the winnable claim, but it seemed like you had quite a number of IAC possibilities, how did you winnow it down to the ones that did you winnow it down to the ones you thought would land more, or was it more, no, I'm going to give everything over, and kind of how do you do that?
I'm not a big winnower. I'm not a big winnower, I should tell you. But I just I proceed on claims that I think have a chance of winning. I was compelled by Dr. Tapper's position. I don't think he was adequately prepped. And I did find an expert, and I didn't have to look far and wide, who would have been very supportive. Had we somehow gotten an evidentiary hearing. How after Shin is a whole other discussion. But I didn't pursue claims that I thought would go nowhere. For instance, in state post-conviction, they raised a claim that the lawyer screwed up the alibi, and she did. She really did. These witnesses weren't prepared; they contradicted each other. But that claim was going to go nowhere. The alibi was essentially presented. It was imperfect to say the least, and it was there were some mistakes that were made, but that would have just distracted the Commonwealth and the court from the issues that had some oomph. I felt that the medical issue was worth pleading. There were one or two others that I didn't plead. They're just not coming into my head. But it's basically, do I think that this is a claim that that merits relief? And on a good day, would a good judge consider granting it? And that's kind of my standard. It's not very. It's pretty pedestrian, but that's kind of my standard. Oh, someone asked what the medical issue was. Well, a good question, and we're assuming knowledge here. I'll tell you real quick. The person of interest stuff related to the fact that CJ had been shot and injured fairly seriously a couple of weeks before this incident. And part of the trial defense was he would not have had the ability to do what the shooter was alleged to have done during the course of the incident, which is, do a lot of running, do a lot of escaping, do a lot of shooting. He was acting like a shooter, and it was pretty terribly presented at trial. It was clear that Dr. Tapper was not well prepped and was really kind of testifying sort of by the seat of his pants, and that was the medical issue. That ineffective assistance of counsel for failing to properly prepare their expert witness, who was also a lay witness, since he was the one that treated CJ. He was CJ's pediatrician, and was prepared to testify that there was no way he could have physically committed this act. 2 weeks after being shot, they had opened up his stomach. They had sewed him up. They had done all kinds of stuff that really left him pretty impaired.
So not that
Katie wasn't impressed.
No, well, I wasn't impressed because essentially, uh, I do believe that Dr. Tepper is very genuine in his beliefs, and he did so much for CJ in this case. So I hate to say anything negative about him, and I'm certainly not doing that. But essentially, the argument was that the shooter was supposed to have run away, and that CJ was too injured to run away. But when you actually read the testimony, the shooter was supposed to have just walked around a corner, open fired, and went back around that corner. So it's not like this person had to be sprinting for many blocks. I mean, they just if they just needed to go back a corner. And there was significant evidence that CJ was in this neighborhood and out of his house for multiple days prior to this shooting. So the idea that he was incapable of walking around is demonstrably proven false. And so given all of that, the medical evidence in this case just wasn't particularly compelling to me.
And Katie, kind of like the inverse of the question to Carl in terms of like how to winnow down, how do you as a prosecutor kind of approach IEC claims in particular? Are you looking for provability? Are you looking for comparing to the outcome from the outset? This is kind of an unusual posture, probably, but what are you looking for? I would guess in an IEC claim, if you're comfortable talking about that.
Sure. So, I mean, in general, first, I need to know what is the strength of the evidence at the trial, because if the evidence is overwhelming, which we not to like to use that word because it can be overused, but if the perpetrator is on video doing the crime, for instance, then very little that the trial attorney did is probably going to make much of an impact. But if it was a very close case, the evidence was very thin. Well, then you look at, with these IAC claims, are these alleged ineffective actions things that could have in fact affected the outcome of this trial? Was it about an important witness? Was it about an important disputed fact? And in this case, even though it only, quote unquote, only went to the motive as opposed to, the testimony of the one witness who had ID'd Mr. Rice, the motive was extremely important. And in fact, when on the Friday before the trial, when the prosecutor was arguing to the judge to allow this evidence in, when the judge was indicating he would not, he said repeatedly that this evidence was absolutely critical to this case. And it was, because the evidence was so thin that if he had no motive for why Rice would have done this shooting, I really do believe that there's a reasonable probability that the jury would not have found him guilty.
But in terms of like so there's kind of like a tipping point sounds in terms of the crime of the claim itself, and then I think you've already explained to us. Then you kind of go through your own information that you have and review to kind of balance out that, I guess, as from an ineffectiveness approach in particular.
Well, it's so hard to talk about every case in the abstract.
Yeah.
Because, for instance, the ineffectiveness could relate to not objecting to an instruction, for instance, that is facially wrong and eliminates one of the elements of the crime. That comes up with unfortunate regularity. And then we don't really need to do much at all of an investigation regarding that. We just need to look at, well, was the evidence here close at all on that element that the jury wasn't instructed on? And then that's the only analysis that we're doing. Whereas in this case, since we needed to investigate what the reasonable strategy of the attorney may have been, then that would involve more of an investigation.
Mm-hmm. Good. Just a pause to see if there are other questions that folks have. To either feel free to go ahead and unmute if you want to, or go ahead and put it in the chat when we go through. So the case, it obviously didn't resolve in federal court, had to go back to state court for resolution. So what was that process like? Was there any additional claims that were being brought forth, or anything else that came up with that, or was it just kind of a straightforward remand from the federal court back to state?
Well, so once relief is granted, it's always conditional. So it's, the petitioner must be released or retried within a particular amount of time. It's usually 120 days, but the judge can set it at whatever amount of time they want to. And that it was during that time that then our gun violence task force completely reinvestigated this case to determine whether we would attempt to retry this case. And ultimately, we're not able to find evidence that would support a new trial.
Mm-hmm. Okay. And Carl, no additional investigation on your end was necessary, it sounds like.
Well, to their credit, I talk about, it's easy to be critical of other lawyers, right? So I'll be a little self-critical. Their their gun violence task force. I forget the fellow's name. He did a fantastic job. Talk about scorching the earth. And he came up with a nugget that didn't even occur to any of us. That was fairly compelling to him. And that had to do with the braiding of CJ's hair. And it's a good lesson in humility because he was described as having hair that did not match up to his police photo, and he could not have had the hair weaved in the way that it appeared in the police photo in such a short period of time. I think I have that right. In any event, you know, and we had the Exoneration Project, we had the Innocence Project, we had Don Varelli, Ginger Anders, myself, and we all missed that issue. So it just goes to show you that there's no I in team, and the more folks you have, especially if you have a DA's office that's willing to do that kind of investigation. I think that's the only thing they found that we didn't find. So I take some solace in that. But to their credit, and this kind of relates to something else. I think alliances are absolutely critical in this work. Not because of the name recognition of having the Innocence Project or the former Solicitor General, but folks like that, folks who are respected in the community, who have reviewed your case and believe it's compelling enough for them on a pro bono basis to step forward and invest time and resources, that means something. I know Katie would deny it, and I give her, and I expect her to deny it. But when Don Varelli, and the Innocence Project and the Exoneration Project, walk in on either side of me to this meeting, it's significant. It means they've vetted this case as well. And there's nothing, sharing credit for these kinds of cases. There's plenty of credit to go around. And we've been at our firm, we do a lot of this work at our firm, and we've been amazed at how willing groups are to look at these cases and join up. And I think that is important, and it's probably underutilized.
Katie, Carl said you would deny that.
Well, I would say that, I certainly, I would absolutely deny, and it's not true that the media attention had anything to do with any sort of decision that I would make. But it's undeniable that if multiple innocence organizations and the former Solicitor General of the United States have decided that this case is important for them to have dug deeply into, and frankly, when I met Don Verrilli, I was expecting him to just be, a prop sitting there. And he clearly had dug deeply into the case and had a lot to say about various claims. And when I would raise concerns about things, he had answers to those questions. And so knowing that all of these well-respected lawyers had looked at this case very deeply and that they had come to a certain conclusion, we were going to do our own independent investigation regardless, but I can't deny that that's going to have an impact to my thinking about a case.
And were there any questions they couldn't answer that you asked that you can recall?
No.
Well, I would say there were like maybe 3 questions at that meeting. They were like, we'll look into it. And then they, of course, sent me all kinds of memos back about it, but I don't remember what any of that was.
Okay. Again, just kind of looking to the chat, not seeing any additional questions, which is just fine. So I appreciate you both being with us and talk. We don't spend a lot of time talking about ineffectiveness claims in particular, and I do think that they're particularly tricky for a lot of the reasons that you guys have articulated. But if you were to kind of give last minute advice for folks both who are bringing the IAC claims and folks who are looking to address IAC claims, so we have both prosecutors and innocence lawyers on this call, what would you say?
Nothing comes to mind other than what we've already talked about, but feel free to reach out. Be happy to consult with anyone. And my law partner has forgotten more habeas and capital habeas than I even know, Michael Wiseman, and he would be more than happy to offer anyone, and does, consults on a regular basis. So feel free to contact either of us. We'd be happy to offer whatever assistance we could.
Katie, how about you?
Advice with IAC claims. I would say that you, if at all possible, you should speak to the attorney if they are still alive and available. It's not that uncommon for us to see petitions where they never actually ask the attorney why they did what they did, which then simply requires us to do so. And that's going to tell you right there if you have any sort of claim.
Mm-hmm. And if they tell you we tried, but the attorney won't discuss it with us, how do you look at that, Katie?
So, I mean, so my unit handles primarily federal matters, but we also do go back to state court at times as well for PCRAs. If we're in PCRA, then we would likely agree to a hearing on the issue if there's a open question, a fact that needs development. But in federal court, we can theoretically attempt to waive E2 under Shin, but that may or may not be successful. And so therefore, at that point, we would just have to see what we can do with the evidence that we have.
And Carl, how about you in terms of talking with, like, how do you have that conversation with trial counsel, which I know you've done in many other cases you've handled? Like, is there kind of a magic sauce for approaching that conversation?
Well, I find lawyers to be much more approachable than you would think. And, I think for me, and everybody has their own style, but I kind of like dealing with the elephant in the room up front. It's an awkward situation. At the end of the day, someone has to admit to their failing. And I try to focus on, trying to help the client out and trying to do it in a way that, isn't humiliating and isn't disparaging. But it's tricky. But I try, I don't, as I say, I try to deal with the elephant in the room, and I don't think I've ever talked to a lawyer without, addressing the fact that this is a little bit of an awkward situation. If it at the appropriate time, I will often mention that, I have fallen on my sword, which I have. I was a trial lawyer for 28 years, 17 of those years doing homicides, and so none of us are perfect, and sometimes that can sound a little manipulative, but in the right setting, it can be helpful.
I appreciate that. So, and one more check of the chat. Don't see any outstanding questions, which is terrific. So first, thank you both so much for your time and willingness to talk to us about this case. I know I've been bugging you both for months, so I'm glad that we were finally able to make this happen. And just for those on the call, we will of course have a meeting next month in June. At that time, we're going to be bringing in folks on to talk about DNA evidence searches and issues particular to DNA case evaluation. So thank you all for coming. We will post this on the Conviction Integrity Resource Center, convictionreview.net, along with every other program that we've done. But again, thank you, Carl. Thank you, Katie, both for your time.
Thank you.